Welcome back to SA Today. The Western Cape High Court has ruled that the province's learner admission systems unfairly discriminates against black and marginalised students. And Equal Education and the Equal Education Law Centre had asked the court to declare the department's failure to plan and place the applicants on time unconstitutional and a violation of their rights. The court has also ordered the department to produce a revised admissions plan aligned with learners' rights within 6 months. And the Western Cape Education Department says it is studying the ruling. But to take this discussion further, let's welcome Equal Education Law Centre representative Sith'enkosi James. Sith'enkosi, it's such a pleasure to have you with us. So briefly take us through this debacle. How did you even become aware of these irregularities and exclusion, specifically against black students, and what necessitated this legal bid?
Good afternoon, Alicia, and everyone at home. Thank you so much for having me. It definitely gives me a great delight to be appearing before you after we've received our pleasing judgment on the 28th of November, 2025. It marks a great milestone for us. Well, so this litigation emanated from the cases that we received from the Metro East District in the Western Cape, and the Metro East District is mainly constituted of Khayelitsha, Kraaifontein, Strand, and Kuils River. And all of those areas are actually areas where you find majority Black learners, right? So when they came to us to tell us of all the the lived experiences that they experience each and every year related to the fact that they spend many years, or rather spend the entire year without having been placed in a school, raised so much concern for us. And that's when we decided that it is actually something that we need to take up with the department. And what I want to flag to literally the entire world is the fact that before there's any litigation that is instituted by Equal Education Law Centre and Equal Education, there's always a mere letter that we give out to the department, outlining all of the issues that the parents often bring to our law clinic, right? Mm-hmm. So before we came to a point where there's litigation instituted against the Western Cape Education Department, there were letters that we sent out to the department outlining all of these issues related to learners not being placed, particularly late application and extremely late applications, as well as transfer applications, actually. And, having seen that the department wasn't making any action regarding all of those things, then we had to do something. And, when we received the judgment, what gave me so much courage to continue doing this work was the faces of the parents, because you could see that they actually feel like their voices are being heard finally. So that's how we got to this point. And you know what? We never fight against the department mainly because of malicious intents. It's never about that. We all have the same goal, which is to ensure that all children enjoy their right to basic education. Now, when either of us are working towards that, then one of us needs to stand and actually hold the other accountable. Otherwise, it was all to make sure that we reach the goal of ensuring that every child, Black or any other color, we need to ensure that they actually have school placements.
I mean, maybe it's Sith'enkosi, great initiative as well as cause on your behalf there. Congratulations into taking it this far. Maybe talk to us about, we've heard the department has said in their official statement that they are still studying this judgment. But in effect, what does this judgment effectively mean, specifically for those parents, as you've just rightly pointed out, whose kids might have had to miss school or not go to school at all because of these discrepancies? What are they saying in terms of making sure that they prioritize these kids that have had probably their learning schedule disturbed in one way or another by these discriminatory processes?
Thank you so much for that. Well, actually, this case came in two parts, right? There was part A, which was seeking an urgent relief to ensure that all of the learners that we're representing in 2024 got placement. So that urgent relief was granted and those learners were placed into schools. Now, the second part, which is the part we have just won in the High Court, specifically just wanted to fight against the systemic nuances that exist within the admissions policy of the Western Cape Education Department. So this particular judgment will actually help us in the next year or two to ensure that at the beginning of mid 2026, beginning of 2027, we won't be having any of the issues of learners who applied late not being placed into schools. So as much as yes, this judgment was granted, or rather this order was granted, we'll start seeing its effects probably mid 2026 and early 2027, because remember, the court did mention that it's giving the department 6 months to ensure that they come with a management plan. So that management plan, we are delighted to give them the 6 months to ensure that they come up with it and they make sure that it serves the ones we serve as well. So we shall wait and see how the department comes about making sure that that management plan is actually implemented.
Sith'enkosi, unfortunately, we're out of time. I wanted to actually dig deeper into this admissions policy that you took so much issue with, but unfortunately, I think we've gotten the gist of your argument, as well as the work that you've actually contributed in raising this scourge of, discriminatory practices. Thank you so much for your time. Sith'enkosi James is of Equal Education, is from the Equal Education Law Centre, talking to us about a recent Western Cape High Court judgment citing that the Department of Education there is in fact using some discriminatory processes specifically against poorer income black students within the admissions policy.